Warm greetings of the day. Dear friends, I am Professor Sharanjeet, working as a professor of law at the Rajiv Gandhi National University of Law, Punjab. In the previous lectures, we have discussed that the law of torts is meant to put a control on the behavior of the people in the society and also to make them liable for their wrongful behavior. In case of wrongful act in the form of a tort, various remedies are available to the injured party. Broadly, the remedies can be classified into judicial remedies and extrajudicial remedies. In today's lecture, we shall be discussing one very significant judicial remedy, that is damages. At the very outset, we need to understand as to what is the meaning of the term damage. The term damages for the purposes of the law of torts means financial sum that the plaintiff claims from the defendant for the tort committed by the latter against him. These damages may include consecutional expenses, cost of care, loss of earnings, and cost of litigation, and non-pecuniary damages include cost of pain and sufferings, loss of abilities, and loss of expectation of life. In the case of common cause, a registered society versus Union of India, 1999, the Supreme Court of India has defined the term damages and observed that damages are a pecuniary sum which is awarded to the plaintiff who succeeds in an action for torts or a breach of contract. Another important thing that we need to understand is that the damages under the law of torts are unliquidated damages, which means that they are not predetermined and the quantum of damages awarded to the plaintiff is decided on the basis of facts and circumstances of each case. Dear viewers, here a difference can be struck between law of contract and the law of torts. In the law of contract, the damages are always liquidated, that is, pre-decided between the parties with regards to a breach of contract. Now we shall move on to the object of awarding the damages. As we all know, damages are considered to be one of the most important remedy under the law of torts. The object of awarding damages is to place the injured party, so far as money can do it, in the position which he would have occupied if the wrong had not been committed. Furthermore, Damages awarded for the pain and suffering takes into account the suffering in the past as well as in the future. It is important for us to understand that damages under this includes physical pain and also mental agony due to the plaintiff's knowledge of the fact of the shortening of the expectation of his life. The objective of this branch of law can be explained with the help of the case Dikana versus Ahmedabad Municipal Transport Service of the year 1976. In this case, the plaintiff who had been injured in an accident was a girl of about 16 years. The accident resulted in permanent incapacity in the form of limp in one of the legs. She was awarded rupees 10,000 under the head personal suffering due to this personal incapacity. Apart from that, the amount spent for medical expenses and compensation for the loss in the enjoyment of life by not being able to participate in sports and household work were also allowed. Consideration was also shown for her diminished prospects of marriage due to this injury. Listeners, now we move on to the next case, that is Karnataka State Transport Corporation versus Krishna of the year 1981. The court observed, if the plaintiff is injured due to the negligence on the part of the defendant, he can claim not only expenses of medical treatment, pain and suffering, but also such amount regarding increase in his cost of future living. It means that if he has to spend some more amount on extra nourishment, transport to and from the hospital or his place of work, or charges for nursing attendance, all that can be recovered. In the next part, we shall focus upon the measurement of damages. As already noted, that the damages under the law of torts are unliquidated in nature, thus, while deciding the plaintiff's claim for damages, the court generally takes into consideration the following facts. Firstly, are the damages claimed by the plaintiff's constitutional result of the defendant's wrongful act? Secondly, were such damages foreseeable under the circumstances in which the tort is committed? Thirdly, what should be the quantum of damages? Furthermore, when there is a personal injury, compensation or damages may be given under the following heads. First, personal pain and suffering and loss of enjoyment. Second, actual pecuniary loss resulting in any expenses reasonably incurred by the plaintiff. Third, the probable future loss of income by reason of incapacity or diminished capacity for work. In the case of Ward versus Kennock Chase, 1986, it was observed that in the property damage cases, the measure of damages will be the limitation in value of the property at a time when the wrong was done, but other formula may be adopted keeping in mind the justice that the case demands. Thus, the cost of repair may be awarded even though it exceeds the diminution in value where it is reasonable. Dear viewers, now we shall talk about the interest on damages. In addition to the damages allowed under various heads, the plaintiff may be allowed interest on the amount of damages from the date of his filing the petition or suit till the date of payment of compensation. Another significant aspect is assessment of the value of dependency. It has been seen that when a person dies, problem often arises in awarding compensation to his dependents. In this regard, two different theories are used. First is the interest theory and second is the multiplier theory. According to the interest theory, the dependents may be paid such lump sum, the interest from which would be equivalent to the loss suffered by them. In other words, it has to be seen as to how much interest a certain amount will bring if invested in a fixed deposit. However, this theory has been criticized in many cases. In the case of Padma Devi versus Kamal Singh 1985, the court observed, deciding the compensation only on the basis of the interest, the lump sum one will receive is an unscientific method. There is a good interest rate only for long-term investment, and the cost of living also increases with every passing year. Therefore, it is not possible to lay down the general rule that while fixing just and fair compensation, it should always be based on the basis of the interest that will be derived or received if the lump sum is prudently invested. Now we shall discuss the second theory, that is the multiplier theory. According to this theory, the unlikely future loss is assessed by multiplying the likely loss due to occur every year with a multiplier which indicates the number of years for which the loss is likely to continue. Certain factors like the age of the deceased and of the defendant may have to be taken into account to determine the multiplier to be used for assessing the compensation payable. An important case in this regard is Municipal Corporation of Delhi versus Subhagwanti. In this case, due to the negligence of the defendant corporation, the clock tower situated in Chandni Chowk, Delhi fell, as a consequence of which 3 persons were killed. The only factor which was taken into account was the monthly earning of each of the deceased, and the amount was capitalized to 15 years to determine the damages payable to the dependents of each of the deceased persons. Now we shall discuss the different types of damages that can be awarded under the law of torts. We shall start with the nominal damages. It is interesting to note that nominal damages are awarded by the court to the plaintiff not by way of compensation but by way of recognition of some legal right of the plaintiff which the defendant has infringed. For instance, trespass, assault, invasion of the right of easements. There may be cases in which the plaintiff has not suffered any financial loss, but his legal rights have been violated due to the wrongful act of the defendant. So, where there has been an infringement of the plaintiff's legal right, but he has actually suffered no loss or harm, so in these cases, the courts generally award nominal damages. It is like a token amount awarded to the plaintiff in recognition of his legal right which has been violated by the defendant's wrongful act. The case of Ashby versus White 1703 is an illustration where the court awarded merely £1 because the plaintiff's voting right was wrongfully denied to him by the returning officer, but though he was not adversely affected by this deprivation of his right in any way. It is important to note that nominal damages are generally awarded in cases coming under the maxim injuria sine damino, which means that the plaintiff's right is violated but he suffers no loss. Now we shall move on to the second head, that is contemptuous damages. Dear viewers, these damages awarded by the court when it is considered that the action should never have been brought. They are an indication of the law court expressing an opinion about the claim of the plaintiff or his proven conduct in the matter. These damages are awarded when the plaintiff has suffered no damage and his conduct is also equally responsible. In such cases, the court generally forms an opinion that technically speaking, the defendant's act has resulted in violation of the plaintiff's legal right, but there was no justification for action against the defendant on moral grounds. The plaintiff therefore has no reason to bring an action against the defendant. The amount of compensation ordered is obviously nominal. In the case of Kelly versus Cheslock, 1866, the defendant published his statement against the plaintiff in the newspaper alleging blasphemous charges. In response to this publication, the plaintiff resorted and used abusive language against the said newspaper and called it a black spot for journalism. Expressing unhappiness about the plaintiff's conduct, the court ordered payment of damages to him under this specific head. Now we shall discuss the third head, that is, real or substantial damages. Dear viewers, the real or substantial damages are the ones which are assessed and awarded as compensation for damages actually suffered by the plaintiff. It is important to note that they are a sum of money that is awarded to the plaintiff as a fair and equitable compensation for the injury suffered by him. General damages are also called compensatory damages because the purpose of awarding such damages is to compensate the plaintiff for the actual loss suffered by him rather than imposing a penalty. While determining the quantum of general damages, the courts may see more to take into consideration the prospective damages which are likely to result from the defendant's wrongful act but have not actually resorted at the time of the decision of the case. In the case of Dipti versus Banwarilal, 1966, a 15-year-old girl who was going to school on cycle was hit by a truck coming from the opposite direction and got injured. The High Court of Madhya Pradesh held the defendant liable for negligence and awarded the plaintiff the cost of medical and other incidental expenses as well as the damages for losing opportunity of spending a happy future life due to permanent disability suffered by her. The court, however, noted that while assessing the prospective or future damages, the court may take into consideration the personal and family circumstances of the plaintiff. Dear viewers, now we shall move to the next category of special damages. It is important to note that special damages have to be specifically averred by the plaintiff in his plaint because the court cannot take cognizance of them unless they are specifically mentioned and claimed by the plaintiff. Thus, the burden of proof is on the plaintiff to show that besides the general damages, he has also suffered special damages due to the wrongful act of the defendant. Special damages are there for the pecuniary equivalent of the additional loss sustained by the plaintiff beside the general damages. In the case of C.B. Singh versus Cantonment Board, 1974, the Allahabad High Court observed that general damages are those which the law presumed to flow from the negligence complained of. These damages must be proved, but it is not necessary to allege them in detail in the statement of the claim. Special damages means some specific item of loss which the plaintiff alleges is the result of the defendant's negligence in the particular case, although it is not presumed by the law to flow from the negligence as a matter of course. full particulars of the special damages must be given. In the case of Veeran versus Krishna Murthy, 1966, where a child was injured by negligent driving of a bus, the court allowed medical expenses for the child's treatment as general damages. Damages for mother's nervous shock were allowed as special damages. Next is the prospective damages. Dear viewers, prospective damages are also called future damages, and these are the damages that are likely to result from the wrongful act of the defendant, but have not actually resulted at the time when the damages are being decided by the court. In the case of Hardeep Kaur versus Union of India, 1975, where the deceased income was rupees 1500 per month, the court awarded a compensation of rupees 96,000 to the father, calculated at the rate of rupees 400 per month for a period of 20 years. The court said that the father could receive this amount from his son during his lifetime. Now we shall discuss exemplary damages. Exemplary damages are awarded where there has been great injury by reason of aggravating circumstances accompanying the wrong. A heavy amount is awarded as an expression of indignation at the conduct of the defendant. He has shown a disregard of the plaintiff's right, and the motive of the defendant is also malicious. The object of awarding these damages is to deter other people from the commission of a similar act. Such damages are sometimes also called vindictive or punitive damages. In the case of Rudal Shah versus State of Bihar, 1984, the Supreme Court held that the wives of two missing persons who had passed through the torture, agony and mental oppression be paid rupees 1 lakh each as damages under this very head. Furthermore, in the case of Lucknow Development Authority versus M.K. Gupta, 1994, the Supreme Court has agreed with the principle that oppressive, arbitrary or unconstitutional action of the government or its servants calls for damages under this particular head. Now we shall talk about continuing damages. As a general rule, all the damages arising from the cause of action must be issued in a single suit, and the law bars more than one suit for the same cause of action. However, where more than one right of the plaintiff has been violated, he can bring separate action for each such right. For example, where due to the assault committed by the defendant, the plaintiff suffers a leg injury and his mobile phone is also damaged, he can either sue the defendant for both in a single action, or he may also bring two separate suits, one for physical injury and the other for damage to his mobile phone, because both are two separate rights which the defendant has violated. Here it is important to refer to the case of Donnelly versus Joyce, 1974. In this case, a 6-year-old boy was seriously injured by the accident caused due to the defendant's negligence and consequently had to be hospitalized for a number of days. In view of his age, his mother had to be with him in the hospital to look after him all the time, leaving her routine job, and therefore she was deprived of the wages. It was held she could sue the defendant for loss of earning in a separate suit. With this, we arrive at the conclusion of this lecture. As already discussed, payment of damages is a very important judicial remedy available to the plaintiff in case of harm or injury suffered by him or her due to the wrongful or negligent act of the defendant. In considering the measure of damages, The leading principle should be based on the fact that where an injury is to be compensated by damages, in settling the sum of money to be given for the purpose of damages, you should as nearly as possible give that sum of money which will put the party who had been injured or who has suffered in the same position as he would have been in if he had not sustained the wrong for which he is now getting the compensation. Thus, the court takes note of various aspects of harm caused to the plaintiff, the injury itself, mental suffering, loss of expectation of life, and the loss of ability to earn in future. The court in many cases has held that the determination of the quantum of compensation must answer what contemporary society would consider to be fair and just. All this means that the sum awarded must be fair and reasonable by expected legal standards of the contemporary society and the prevailing cost of living. It is very important to note that in calculating damages to which the plaintiff is entitled to in respect of an injury, the court has to take into account as to what would be the particular sum which will make good the loss suffered by the sufferer so far as money can do it, and will try to make good the loss which he has suffered as a natural result of the wrong done to him. This rule is, however, subject to the rule as to the remoteness of damage. In the end, I would conclude by saying that while awarding damages under the law of torts, the judiciary must ensure that true justice is actually done to the plaintiff. Thank you.